versus Brendan Williams.
Brendan Williams, who is present via Zoom. Please unmute and state your name for the court.
Brendan Williams.
Gunnar, Miss.
This case opens quietly, but don't let that fool you. What starts as a routine court call quickly unfolds into a textbook example of workplace trusts being broken, legal consequences catching up, and how even a small dollar amount can carry serious criminal weight. An employee, a position of trust, and a decision that leads straight into a guilty plea. Stay with us, because the details matter, and the law does not overlook minor misconduct.
Ms. Lonnie Feltus did provide me with a plea form regarding this case, and I believe that will be entered. However, I need to have my client review that and discuss it with him. I would request two things for a brief adjournment, and then also, Mr. Williams, if you could possibly update your phone number if you did not get my text. I believe your voicemail box is not set up yet either. So thank you so much, sir. Thank you, Your Honor.
All right. Thank you. November 19th, 2025, 9 a.m. I'm continuing. Court calls case People versus Brennan Wilson.
Good afternoon, this is Pope and Lauren on behalf of Mr. Wilson. Mr. Wilson, state your name for the record.
Brendan Wilson.
Is your last name spelled with two L's?
Correct, yes.
Okay, very good. All right. I have before me a plea form that indicates that the defendant will be pleading guilty to count 2, embezzlement under 200, the 93-day offense. Upon this successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing.
This moment is critical. The court clearly explains that this is a misdemeanor embezzlement charge under $200, but make no mistake, misdemeanor does not mean meaningless. The judge lays out the legal exposure, up to 93 days in jail, financial penalties, and even a fine multiplied by the value taken. This is the legal system emphasizing accountability, especially when the offense involves a breach of trust as an employee. Viewers should ask themselves, was pleading guilty the smartest move here, or should the defendant have fought the charge?
Agreeing to make restitution as ordered by probation, and also the prosecutor and defendant agree that people do consent to HIDA.
That's all correct, Your Honor.
That is correct.
All right. Mr. Wilson, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Brendan Wilson.
Okay, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of embezzlement by an agent or trustee under $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property which is taken or the subject matter of the embezzlement. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty that you'll not have a trial of any kind?
Yes, sir.
Hang on. You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please. You understand that you're giving up all the rights that are contained on that form, inclusive of those rights contained in paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
May 21st, 2025, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, state of Michigan. Were you an employee at Meyer?
Yes, I was.
And what'd you do that makes you think that you're guilty?
I wrote myself $200 worth of bottle slips that I shouldn't have.
Here's where the case becomes real. The defendant openly admits to writing himself bottle slips he wasn't entitled to. No excuses, no deflection. This admission confirms intent, opportunity, and lack of consent, which are key elements of embezzlement. It also highlights how internal access can be abused in ways that seem small but violate fundamental workplace trust. This raises an important question for viewers. Should employers tighten internal controls, or does personal responsibility always come first?
All right. And this was money that the ultimate goal of this is that you were going to take money that belonged to the principal, that being your employer, Meyer,
Yes, sir.
and you didn't have their consent to do that.
No, sir.
And you were able to do this by virtue of the fact that you were employed as a Meyer employee, correct?
Correct.
All right. Sir, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, that you commit misconduct as defined under the Michigan court rule, that you would not be entitled to any sentence evaluation and or recommendation, and the court would not be bound by that, and you would not be entitled to withdraw your plea. You understand that?
Yes, I understand.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Satisfied, Judge.
All right. Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be December 10th, 2025, 9 a.m. or as your invite indicates. All right, sir?
All right,
Bond,
thank you.
bond will continue. Sir, I need you to wait online. I'm going to put you into a breakout room with our probation department so we can begin the sentencing process. Okay, sir?
Okay, thank you.
Thank you. Court calls case People versus Sabra Bell.
Conrad Sora on behalf of the Teal Township.
Public defender Natalie Bell gave me permission to accept the offer on her behalf.
And Your Honor, I'm going to move that count two double parking. If you accept that admission, I will dismiss the original charge.
And Ms. Pate, on behalf of your client, do you bear responsibility to the fact that on July 4th, 2025, Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, is a parked a motor vehicle?
Yes.
Court will accept that admission to count two. Count one is dismissed. Fines and costs of $180. When can she pay it?
Your Honor, she is asking for 60 days. She did advise to me that she is currently 34 weeks pregnant as well, and says that she originally asked for 30. Then, like, to be really honest, I really need 60.
So hold it. The way I count that, that's so if I give 60 days, she's gonna be in the throes of labor.
I know. I wondered if maybe like there's a lottery or something she's winning when her child is born. I don't know.
What?
I don't know.
I wasn't going there. I was just doing the math. And okay.
She'd asked for 60, Your Honor. That's what.
So she's due sometime in December, January. That's
Um,
probably about earlier than that.
that.
Ms. Perroni is going to speak to us as an expert. Everybody pause a moment. Ms. Perroni.
I think she deserves a big pot of money when she gives birth, but that's, that has nothing to do with my situation or my life. I just.
Whole unbiased analysis. Okay.
What I can say about this, she's been very communicative. I didn't even have her phone number, like from arraignment, but she called our office, super nice to me. So I would ask for 60 days on her behalf.
There's no way I can look good at this at all. I'm just saying. I accept it. February 28, 2020.
In the end, the court accepts the guilty plea, dismisses the remaining count, and orders a pre-sentence investigation, showing both firmness and procedural fairness. The ruling reinforces a broader message. Financial misconduct, even under $200, carries real consequences when trust is violated. The law weighs honesty, accountability, and future conduct carefully before sentencing. If you found this case as revealing as we did, hit the like button, share your thoughts in the comments, and subscribe for more sharp, no-nonsense courtroom breakdowns that expose how justice actually works.